person who speaks. Yeah. Okay, this is our second session. Today we're going to be talking about separation, divorce, equalization, and spousal support, all those kind of topics as a second session. Just want to let you know that these sessions are a partnership between Muslim Legal Support Center and the Coalition of Muslim Women through the program called Toward Violence-Free Homes. Before we start, I just want to give quick note. As many of our participants today are service provider and they don't have the background of the Islamic like marriage and stuff like that. So just want to let everyone know that the primary audience for these sessions are Muslims. But although this that definitely doesn't mean that those information provided will not be helpful for others. But no, it is very helpful for racialized community and everyone is joining us. We understand that this information will be helpful for the service provider as well. We welcome that and are happy to facilitate this work, knowledge transfer. The only caution we would put forth on that aspect is that the primary audience has lived experience and has a lot of backgrounds of these issues. For the service providers and others who don't have the lived experience, we urge you to seek more knowledge to understand the complexity in this issue. We say this because we are concerned that without that holistic context, there may be some unintentional harm on those who are served. CMW has training and programs that provide that deeper context. Please connect with Sarah Shafiq, our program director, who also work on those trainings to discuss further or if there is something that you didn't really understand regarding the Islamic backgrounds on those issues. I'll be putting Sarah Shafiq email in the chat, so you can just drop an email and ask her your questions. I think we can start now. Lina, it's all yours now.
Awesome, thank you. So welcome back, everybody, for the second week. Today we're going to be talking about separation and divorce. As always, I will start off with the note that the information that I'm going to give you today is just that. It's information and it's not legal advice. So what that means is if you need any specific advice for your specific situation, you should talk to a lawyer. The information that I'm giving you today, it's intended to help you identify what it is that you want to talk to a lawyer about. So I'm going to try and discuss, the key terms and some of the general concepts. So today we're going to talk about ways of ending a relationship. We're going to talk about divorce and an annulment. And I'll just pause here to say that whatever questions you have at the end of presentations is something that if they're not addressed in this lecture or if they're not related to this series, I do hope to incorporate them to future series. So for example, annulment, the reason I included that on the agenda today is because there was a specific question about that last time. So we'll talk about divorce, we'll talk about annulment, and then we'll talk about the rights upon separation. So what does property division mean, equalization, and then we'll talk about your rights to the matrimonial home, living in it and getting a share of it. And then we'll talk about spousal support. And we'll pick up the conversation from last week about alternative dispute resolutions in the form of domestic contracts and how those affect the specific rights for separation. So divorce. I tried to make it a little bit more engaging with the visuals. So the basic 3 requirements for a civil divorce is that you have to be married. That means that if you're not married, but if you're in a cohabitating relationship, a common law relationship, you can't get a divorce. The second one is that you have to have a marriage breakdown. And there are 3 grounds for divorce underneath that. So you have to either be separated for at least 1 year, or you might want to claim that the other person has committed adultery or is physically or mentally cruel to you. So just a note here, the separation for at least 1 year doesn't mean that you have to commence divorce proceedings after a year. In fact, a lot of people will do it at 6 months after they started separating because divorce does take some time. So if you want to ensure that you're divorced right at the year, then you might want to consider commencing it beforehand. And then we have the requirement that is specific to different provinces. So in Ontario, and this may be different in other provinces, but you have to reside in Ontario for at least a year if you want to commence your divorce proceeding in Ontario. There is an exception. It's typically designed to cater to divorcing from LGBTQ kinds of marriages. And that exception essentially says that if you're married in Canada and you don't reside in this province, or perhaps not even in Canada at all, and where you do reside is a place that doesn't recognize your marriage, and so you can't undo that marriage in that place, then Canada will divorce for you. They will help you get out of that relationship which you started in Canada. And so, like I said, it's not really heavily practiced because it's more and more countries across the world have started to recognize marriages, which Canada does. And all of these three requirements of being married, proving one of the three grounds of marriage, which is defined as a marriage breakdown, and residing in the province in which you initiate the divorce in, is what typically grants you the civil divorce. So here's really important to notice that a lot of the other things we're going to talk about today, especially the rights upon divorce, you will be able to dictate what you want to happen in the way of a contract. You can't do that when it comes to divorce. There's only one way to get divorced. I mean, there's more than one way, but there's only one person who can grant a divorce, and that's a judge in a court. So you have to initiate a divorce in a court of law. That means that if you get a religious divorce, you're still married in the eyes of Canadian law. And even if you put it in your domestic contract that if this happens, I'll be divorced, that doesn't really mean anything. With one little small tangent with respect to the year of staying apart and separate. So if you apply for divorce on the basis of a 1-year separation, you can still live together for up to 90 days, either before or after you file the application, to try and reconcile. So if things don't work out, you can continue your action for divorce as if you hadn't spent the time together. So let's say I wanted to start the 1-year timeline. And after a month, I say, you know what, I want to try it again. Let's see if the marriage is going to work. So I go back and I reside with my spouse. It doesn't necessarily mean that, let's say I only stay there for 1 month, which is less than 90 days. If I leave him again, I haven't restarted the 1 year, right? Like you can interrupt the 1 year for a period of 90 days. You can put it on pause and resume the clock if you're attempting to reconcile, as long as that period of reconciliation is less than 90 days. So that's the basic elements and ways of getting a divorce. The other thing to keep in mind is that there are two main types of divorces. So if you want to file independently, you can do so, right? And sometimes when you file independently, it's going to be contested and sometimes it won't be. So essentially what happens is if let's say I file and then a period of time goes by and I don't hear back from the other spouse, that would be considered an uncontested simple divorce. There's also an uncontested joint divorce. That's when my spouse and I go together to court and say, you know, we both want to divorce, and you know, we agree about everything typically. And sometimes what happens is a lot of people may want to proceed in getting a simple divorce. As the term implies, it is cheaper, faster, it's much easier. But the recommendation usually is to make sure that you're going to also create that separation agreement. So if you remember last week, we spoke about different contracts. A separation agreement is one of those contracts that you can write to make sure that whatever it is that you're agreeing on, let's say it's support, it's property division, these things that we're going to talk about later that are triggered upon separation, that you want to make sure you put those in a contract so that you don't end up having a contested situation later on. So sometimes what happens is if you started off as uncontested, and let's say it's an uncontested and simple. So I'm just going and I file something with the court. If the other person responds saying that, I consent to the divorce itself, but I don't agree about the other types of things that you're asking for. Let's say it's support or property division. That will then obviously delay the process. So it's usually prudent to try and make sure that you agree on as much as possible. Not all divorce procedures have to be very convoluted. It can happen in a simple way. So the suggestion is trying to file a separation agreement along with your joint and contested divorce. So an annulment. Like I said, so an annulment is something I decided to include because of a question from last week. It is essentially the court saying that you were never married, right? It's saying that when you got married, it was perhaps it was an illegitimate marriage because perhaps it was a polygamous marriage. Maybe you were underage. Maybe you were forced to enter. So if you remember last week, we spoke about all the different types of procedural barriers or guarantees that have to take place in order for a marriage to be valid and be recognized. Let's say one of those didn't take place and you both thought you were married or one side thought they were married. What you can get and ask the court for is, instead of getting a divorce, it's an annulment. So it's just a recognition from the court that you never really were married. So sometimes instead of an annulment, it might be called voiding of the marriage or nullifying the marriage. But the requirements in order to get an annulment are pretty difficult. This is because, unlike in divorce, where if both parties consent, you can just file, like I said earlier, and ask for a joint divorce proceeding. There's no comparable process. The only way to get an annulment is to go and present your case in front of a judge. There's no paper-based trail to get an annulment. You have to end up going through an actual court proceeding. So it's very different than the ease and that can take place when you're trying to get a divorce. The other thing is that sometimes people might like it just because of the comfort of saying, I was never married. However, it doesn't really doesn't necessarily get rid of your responsibilities of property division and spousal support. And that's because if you married in good faith, so let's say that you didn't know you were entering into a polygamous marriage and then you're asking for an annulment, or or for whatever reason, if you thought that you were in a valid marriage, then you still have those rights and obligations, and the other side still does towards you as well. So just because you get an annulment, just because it says that you weren't married from the start, doesn't mean that you won't be treated as if you were married when it comes to getting some of these rights, which again, we're going to talk about in a sec. So when can you get an annulment? Typically, a court will grant one if you have problems with your marriage ceremony, like I said about, if one of the spouses was already married and you were an additional spouse, if you were underage or the other side was, if you're akin, as defined by the statute of being really close by blood, or if it was forced and it wasn't voluntary. The other thing is if you're unable to have intercourse due to a physical inability or mental condition unknown at marriage. And it's important to note here that it's really if somebody is unable to have sex. It's not about somebody or both parties not wanting to. It's engage in those intimate relationships. It's really that one side didn't know that the other party was incapable of engaging in intimacy. So those are reasons that a court may grant one. Like I said, it is rare, but typically a court will not grant one just because you were married for only 2 or 3 days. That's not a reason to get an annulment. You would still have to go through a divorce. As soon as you're married, you're married. If you did it right, you have the consequences of it, even if it's only for a few days, like I said. The other thing that an annulment doesn't solve is if you didn't actually intend to get married. So for example, if you just wanted to do the marriage paperwork just to immigrate, that doesn't mean that an annulment is just going to solve the problem. You're still going to be married and treated as a spouse. You still have to go through a divorce and the procedure for that. One thing to keep in mind is that different religions have procedures for annulment. In Islam, we have both religious divorces, religious annulments. If you were to get a religious annulment, that's not the same thing as getting a court-ordered annulment. And so that's because there's going to be maybe different conditions. And like I said, there's only one person in the eyes of this country who can decide upon your marital status, and that's the court. Okay, so we're going to talk about rights upon separation now. So we've now discussed the different methods of divorce and annulment of breaking a relationship if you were married or if you thought you were married. And then, like I said, for common law, there is no real procedure to break or end that relationship. Common law spouses aren't married in order to get a divorce to begin with. So now we'll talk about rights upon separation. So the primary ones we're going to focus on today is property division, the matrimonial home, and spousal support. And we're going to touch on the differences based on whether you're married and or if you're just cohabiting, i.e. you're in a common law relationship. And if you remember from last week, we also spoke about the child-related rights. So those don't matter based on how you ended your relationship. So whether you get a divorce or an annulment, or if you were married or not married, you can always claim those other rights of child support, decision-making responsibility, and parenting time. So with respect to property division, if you were only a common law spouse, i.e. you weren't married, there's no statute or no statutory right to get any share of property. So instead, what's yours is yours, what's mine is mine, what I brought into the relationship and however much it increased in value, and whatever I bought throughout the relationship, that's always kept separate. However, like I said, you can always enter into a contractual obligation. So if you were to sign into a cohabitation agreement, as long as those rights, as long as the way in which you wrote the cohabitation agreement followed the rules of the domestic contracts, which we spoke about last week, then it should be enforced by a court. The other thing that you might be able to get is that you might be able to get some rights through the use of equitable remedies. So even though there's no statute saying you are able or eligible for XYZ, you might be able to say that there's just something so unfair that happened to me that through this vehicle of a constructive trust, I deserve something. And so a lawyer is definitely needed to engage in that process. It's not an automatic right whatsoever. And just to remember, if you are in a common law relationship, you don't have to sign a cohabitation agreement before moving in together. You can do it while you're residing together to protect these kinds of property divisions. So if you are married, what does it look like? The basic idea is that once you're married, everything is shared, right? So whatever I am going to do to increase our money during the marriage, it doesn't matter who's earning that money. It all goes into one pot and we share it all. So even if one person isn't working and the other person is working, the idea of property division is that we're dividing the property equally. And we're going to go through an example of how this division actually works and what is counted in and what is not counted in the property that we're going to divide. So the time limit to make a claim for this is 6 years after the day of separation or 2 years after a divorce, whichever is sooner. So it's not a rush to do right away. You do have some time to to try and get your share of the property. And just to note that we talked about last week that if about polygamous marriages. So if a woman residing in Ontario was part of a polygamous marriage that took place in a country that recognizes polygamy, so not in Canada, she can still try and claim property division under Ontario's statute. So she isn't excluded from property division rights or from sharing parts of the property just because she got married in another country that accepted polygamy before coming to Canada. So even though she's not considered married, and even though those who are not considered married, such as common law spouses, are not entitled to property division, she would be. So we'll go through an example here. Essentially, on the left, I have listed the things that are shared and the things that are not shared. And the key thing is that whatever property you got during marriage is what is shared. So that means that whatever property you got after the date of separation and before you had gotten married is not shared. So typically what happens is you look at how much money each person has when they're separating, right? And separating means when you decide to stop living together. So that's going to be a year typically before you're divorced, right? And if you're not, or if you are still living in the same house, it's okay. You can live under the same roof and still be separated. You just have to sleep in a different place. You have to just, and if you only have one place to sleep, that's okay. It's not like a very strict test. It's just to say that, are you living independently? Are you sharing, are you still sharing one bank account? Are you eating together? Are you celebrating together? Those things, there's a long list of factors that can help somebody describe that type of relationship and saying whether you're separated or not. It's not a very strict test. Not everybody has the means to afford going and renting out a separate apartment. And that certainly isn't the only way to be separate or living separate. So, so the date of separation, whatever money you have on that day, you subtract from it whatever money you had when you were married. And what you end up with is the amount of money that you have gathered throughout the marriage. So like we said, that we're only sharing the amount of money you got throughout the marriage. We are also sharing the value of the matrimonial home. So there are certain rights to the matrimonial home, both living in it and sharing the value of it. It doesn't matter who is technically the owner of it on paper or who has legal title to it. The relationship of marriage comes with certain rights. We will talk about them a little bit later, but with respect to dividing property, it's important to know that you will you do that subtraction, and then you can you're also going to end up sharing the value of the matrimonial home. So in this example, we have spouse A. They had $100,000, and this $100,000 does not include any gifts they have, any inheritances they got, any property that they specified in a contract saying that they were going to keep. This is just the money. This is everything else essentially. And like I said, it's not any property that they got after the separation. And then you're going to subtract from it the $20,000, which is the amount of or the value of the property they had when they entered the marriage. And then the result would be 80,000. So this 80,000 represents the amount of money they got from the marriage, during the marriage. And so that's the amount of money. It's called the net family property that I'm gonna show you in step 2 how we equalize that. So for spouse B, on the separation date, they had $55,000. When they were married or when they entered into the relationship, they had 25. So when you subtract it, it's 30,000. So you have one spouse that has 80 and the other spouse that has 30. And what we do is we essentially subtract it, and that's what we share in half. So it's not exactly just 50-50. What's happening is it's 50-50 of the amount of value of property that they got during the marriage. That's what this exercise does. And so it's equalizing whatever profits they made during their relationship. So that's essentially how this works. I will give you the slides so you can review this again, but it's essentially just sharing whatever profits you made while you were together. So if you came in with a lot of money, that's not necessarily going to all be shared, except for the matrimonial home. Like I said, that's still going to be shared. Okay, so here we are at the matrimonial home. Essentially, during marriage, you have certain rights. During separation, so during that year, you have certain rights, and then upon divorce, you have certain rights. The matrimonial home, it doesn't have to be an actual home. Everybody can describe it a little bit differently. Everybody's house or home means a little bit different to them, but it's where the spouses ordinarily lived during their relationship. And so, like I said, the idea is that the family law regime gives rights to couples outside of the property law regime. So even if the person doesn't have technically ownership over the place, it doesn't mean that the other spouse is now left to has no rights under in the law. So while you are married, both spouses have an equal right to stay in it, unless there is a court order or an agreement that only one person is going to be in possession of it. Otherwise, no, he can't or she can't kick you out of the house. That's against the family law. Neither spouse can sell or mortgage it without the other's written permission. Again, so even if you technically own the entire house, or if he owns the entire house, nobody can just sell it without the other person's permission. That's also a violation of the family law rights that you have during marriage. And then during separation, so you still both have the right to stay in the home, just as you did during marriage. So even though you decided to move out, that doesn't mean you're giving up your rights to stay in the home. And we did speak earlier about the attempt to reconcile, right? So you can move out and try to still reconcile. The idea of having a 1-year separation isn't supposed to prevent you from accessing the house again, or fixing a relationship which you think you want to try and fix. You also have the right to share the value of the home. So again, like we said, when we were talking about property division, you are sharing all of the profit made during the course of the relationship. You also share the value of the house, even if you never bought it, even if you didn't give a penny towards it, as long as it is the marital home. And then upon divorce, each spouse has the right to share the value of the home. Once you are divorced, you no longer have the right to stay in the house because you're no longer married, right? So that's something that you have while you are married and before divorce. During separation, you're still technically married, and so you still have that right to stay in the house. For common law or cohabiting couples, they don't have those same rights. So if one spouse owns the home, they can do whatever they want with it. They can sell it, mortgage it. You don't even need to tell the other person, let alone get their permission. And you don't have the right to stay in the family home unless you are on the lease or you have those property law rights. But the family law doesn't give you or entitle you to any type of possession towards it. And then the other type of rights that you might be entitled to upon separation is spousal support. So spousal support is something that both common law and married couples are eligible for. So technically you're entitled to it if you were married, if you were lived together for at least 3 years. So doesn't mean a common law spouse that's only been together for a year, unless they had a child together, which is the third bullet point. So it doesn't matter for how long you lived together. If you did have some sort of relationship where you engaged in a relationship of permanency and you had a child together, you can be entitled to spousal support. But even if I was married, even if I had a child, even if I lived for 10 years, it's not an automatic right that I would get upon divorce or separation. You would still have to demonstrate at least one of the following things. So you have to show that potentially my relationship prevented me from building my own career. So for example, I stayed at home and I gave up my career in order to take care of the kids, or I gave up my career to help my husband build his career. So that's the first bullet point. The second is that maybe the separation left you in need of financial support. And the other spouse can't pay it. So he either has income or he has assets that he can sell to pay. And then the other way of triggering spousal support is, of course, if you have an agreement. So if you have a contract that you both signed onto that says, upon separation, we will get spousal support. There are a lot of other factors that can be considered to know whether or not you're eligible for spousal support. And the amount is also dependent on a lot of factors. It's dependent on how long you live together. It's dependent on how many children there are. It's dependent on what roles each person took during the marriage. It's dependent on the likelihood of one spouse becoming self-sufficient after receiving support. And it's dependent on whatever other types of support arrangements were made aside spousal support as well. So some of the other things that are also considered is, will the support compensate the lower income spouse for the power to earn income that he or she sacrificed during the marriage? So if one person, like I said, gives up their career, how do we value that? How do you measure the loss of a career on somebody's life? Let's say that they had invested X amount of dollars into going to professional dentistry school, whatever it is, and then due to the relationship, they lost all of that investment that they put in themselves. How do you calculate that, right? There's a lot of financial difficult questions that have to be made, and are usually answered with the help of financial experts, so not just lawyers. And there's, like I said, there's so many different factors that play into the amount, but one thing that does not influence the amount of spousal support is if one spouse cheated on the other. So Canada has a no-fault divorce rule, even though one of the grounds of divorce, it can be trying to prove adultery or cruelty. That doesn't mean that infidelity has anything, it doesn't play any part in the calculation of spousal support or the obligation of financial support in any way. And so I did include a link here, mysupportcalculator.ca. There are a couple of different calculators online that you can try and type in your factors and see how much money you would make. There are federal guidelines that are supposed to try and guide the calculation. And so that's what these calculators are typically made based off of. And then we're going to go off of some examples. I'm seeing the questions. I think maybe we can answer them first, just before we get into the examples. So the first one is, so if a couple gets a divorce and they can't force the other to leave the marital home, even if they get a divorce, then in theory, someone can just live in that home forever, even though the other owns the house. So just to clarify, once you are divorced, then you no longer have the right to live in the marital home. So if I go back to the slide for a second, if a couple does get a divorce, we are now in the third column. And so upon divorce, you no longer have a right to stay in the home. So no, they can't just live in the home anymore. It's only during that time of separation where you're not divorced yet, but you're trying to, decide whether you want to leave, you live separate lives, you live in a different place, or perhaps you're just trying to trigger divorce after a year. That is when you still have the right to come back to that house, even if you don't own it. So I hope that answers that one. Is it true if two partners fighting and they do not want to leave the house? In that situation, both live in the same house, basement for one, and the other area of house for other. They live for a year as separated, yes. So they can file for a divorce, can both stay in the same house, and what is the proof? So yeah, like I said, living separate and apart doesn't necessarily mean that you have to live under a different house or a different roof. Not everybody can afford that, and that's not the only way to get divorced. Typically, there's a long list of different things that somebody can consider, but as long as you're living independently, what that means is you're no longer relying on each other. You're trying to become financially independent. You're not eating meals together. You're not sleeping in the same place. A basement and another area of the house is a perfect example of how you can live separate and apart in the same house. That is still considered living separate. So, and with respect to how they prove it, there's a lot of different evidences that you can show, especially, I mean, if two people are, not on the same page, things can get a little bit more tricky, but it's actually not that uncommon for people to live separate and apart in one house. So it's not something that is very rare or surprising. It happens quite frequently, more often than not. Okay.
Do you want me to continue reading, Lina?
Sorry?
Do you want me to continue reading for the questions? Or would you like
Sure, that would be lovely, sure.
Yeah, you can have a little bit break on that time.
Yeah, thanks.
The next question is, can you make your own separation agreement and file it on your own?
So yes, you can. Just make sure that you're following all of the right rules. So domestic contracts have to be signed, witnessed. They have to make sure that you're doing that. Typically, you have independent legal advice. What that means is that each side of the separation agreement has had it reviewed with their own lawyer. So the husband gets it reviewed by their lawyer, the wife gets it reviewed by their lawyer. And that's not technically a requirement, but it's going to make it a lot harder to challenge how much you can enforce that separation agreement. And then you can file it on your own. And there's a specific way of actually filing it with a specific family responsibility office if it's with respect to support payments. So it's not just filing it in court. There's actually an enforcement body that makes sure that these separation agreements are being complied with. So I think that's the answer there.
Thank you so much. Farhanda, would you like to ask your question?
For me, Farhanda, yes.
Yes.
Actually, I'm divorced and my child is over 18 years and one is 17 and a half. But they don't want to meet the father now. They said, now we are 18, we don't want to meet him because we meet always once in a month. So when they can decide to don't meet the father because they don't want.
Right. I mean, even though they're technically not adults yet because they're not 18 yet, 17 is almost there. I think that it's not something that's very black and white about them deciding that they don't want to meet the parent. A court's always going to look at what's the best interest for the child when it coming to these decisions. So if there's any harm or anything that may be motivating their decision to not want to see the other side, there's a lot that goes into it. It's not just what does the child want, even though that is one of the considerations, especially as they're more mature. At the end of the day, it's really what's in their best interest.
What is the age? I want to know what is the age when they can decide.
So in Canada, once you're 18, you are considered an adult. And at that point, the parental kinds of arrangements shift and change.
Okay, thank you.
Yeah, you're welcome.
Yeah, would you like me to ask the questions on the chat or would you like to continue to the slides?
I think we can continue the questions just so that we get through them, and then we can do the examples after that.
Sure. Next question is, what about pensions in the equalization?
Okay, so to be completely honest, I don't know off the top of my mind, but I know that certain insurances are not included, so I'm not sure, to be honest, about that one.
Yeah, thank you. How does one cheating on a partner affect the divorce, custody, etc.?
So like I said, cheating on a partner is not going to affect the divorce. In Canada, we have a no-fault divorce process, right? So cheating doesn't mean that one person's going to make more money or less money. It actually doesn't really affect at all. The only way that cheating can affect the divorce process is if they actually committed adultery, right? And if you want to divorce on the basis of adultery, then in that case, and that is the only way that that would have any influence on the divorce process. However, if you don't want to go through the hassle of proving to the court that one spouse did commit adultery and you are going to proceed based on living separate and apart for a year, then cheating means nothing during the divorce procedure.
Thank you. What if the wife wants a divorce and she's not working or even has her PR yet, which is still under process, and she's having 2 kids, Canadians, and she can't continue the relationship because of many problems can't solve? What is the right she can have in this situation whilst she's scared to be deported or lose the right to stay with her kids just because she's still not immigrant?
Right, so we're going to talk about immigration status and the overlap with family in a following series, but I do not believe that her getting divorced is going to automatically mean that she's now going to be deported. But I think that that's not a typical scenario. However, we can discuss that further at a later series.
Thank you. For how long one partner should support the other one after divorce? If a woman is earning but husband makes more money, then will he support her, and for how many years?
So the duration for spousal support is something that is going to differ from one relationship to another, and it typically depends on how long the marriage was for. So for example, if 2 partners, they were married for 20 years, they have become very dependent upon each other. And so at divorce, now that that dependency is really hard to become self-independent. And so typically a court will ask that or will order spousal support for a longer period of time. It's not that black and white. It's not that every short relationship is going to have a short period of spousal support, but it is a very big indicator of the length of time that you're going to be paying spousal support. It is correlated to the length of time that you were married.
If there is kids and the mom is taking care of them throughout custody, can she ask to live in the house upon divorce? And if she agrees to pay half rent to the husband?
Right, so she can always ask. Once she's divorced, she doesn't have any right to live in that house. They can always make some sort of an agreement to pay half the rent to the husband, but again, she doesn't have any marital or family right, at least in Ontario, that says that because she is taking care of the kids, that now she has a right to live in the house. That's not something that is automatically entitled, but again, you can always create these types of arrangements through a contract if that is signed and witnessed and filed.
Next question is, if a person bought a house before marriage, does the other person get a piece of the value of the home upon divorce? If yes, then what if they sign an agreement before marriage stating that the house value will be entirely for whoever bought it initially?
Right, so the answer is yes. It doesn't matter who brought the marital house into the marriage. It does have to be the house that they both live in and treat as their marital house though. So let's say I own 5 houses and I enter into a marriage. Not all of them now have to be shared upon divorce, right? If that is the house that they live in and treat as their marital house, that's where they live and that's where they eat, that's where they have, where they raise their kids, yes. Doesn't matter who owns it, doesn't matter when it was purchased, before or after, that is something that is going to be shared. So what if they sign an agreement? Yes, that happens very frequently through a marriage contract. Sometimes they're also done before marriage, and they're known as prenuptial agreements or prenups. And those are typically enforceable, right? So you can contract out of these rights to protect your property and assets that you bring into a marriage. And that's something that's very frequently done.
Thank you. There were addition for this question. Does the wife has right over the pension 2 of her ex-spouse, or it's under mutual right or court decision?
Yeah, so again, I'm not really sure about the pension questions.
Next question is, children can have access to the office of the children's lawyers. They have rights at 12 in the family court. Okay, it's the, yeah, thank
Yeah,
you.
so yeah, the children's lawyer typically represents the views of the child. So if you're in a court proceeding, the child wants to express themselves, typically they're going to have that legal representation available to them once they're 12.
Yeah. Does the parent who is earning more, if he makes more money, for how long will he support the child under 18 or?
Right, so we're going to be talking about child support later, but it is true that he will need to support, and typically child support also is until they are no longer a child, at which point it is 18. However, that's not always the case, especially if a child is, for example, has any kind of physical or mental disability. There's, I believe it can go up to 25, but we will discuss the details of the child support at a later series.
Thank you. Is there an Islamic divorce field in Canada too, or is it only Canadian way?
So, like I said, a religious divorce does not mean you are no longer divorced in the eyes of Canadian law, right? So there's only one person or one role that can get you divorced in Canada, and that's the judge in the family court. So an Islamic divorce might change your moral responsibilities, your religious responsibilities, but it doesn't change your civil or legal obligations when it comes to spousal support and child support in Canadian law. A religious divorce would just change your religious obligations. It might enable you to have different rights and obligations that you would dictate in your private life. However, it wouldn't change, or it wouldn't trigger any of these other rights that we're talking about when we're saying that you have rights to the marital home, when we're saying that you have spousal support. Those are things that are triggered upon a civil divorce.
I am unfamiliar with Islamic divorce. Can you explain more, please?
So I think maybe we can perhaps continue through the examples, just because I think the idea of the presentation is to try and get through the Canadian law for Muslims, right? So, but in short, an Islamic divorce, there are different methods and different ways that an Islamic divorce can take place. Typically it's something that is initiated by the husband. It doesn't have to be, though. An imam or a religious leader is typically involved in mediating and trying to resolve those and grant civil divorces. So, or Islamic divorces, apologies. So again, it's a different concept. It's not really something that I intended on going in detail here, but it is something that perhaps a religious leader can provide more detail on. I'm not a religious expert.
Next question is, if one spouse receives inheritance, then do they share this too upon divorce?
No, inheritance is not shared. If I get an inheritance during marriage, I do not have to share that with my spouse upon divorce. It's treated like a gift. If I get a gift during marriage, it is not something that I have to share upon divorce. It's just not even calculated into how much money that into the equation. Okay.
Another question is, if wife is delivering false statements to the authorities about husband to get out of marriage and also not allowing their 18-month daughter to meet the father, in spite the wife is delivering false statements about the father, and daughter relationship just find to an excuse not allow father to meet his daughter, what are the obligations of it?
I'm sorry, do you mind repeating that?
Yeah. If wife is delivering false statements to the authorities about husband to get out of marriage and also not allowing their 18-month daughter to meet their father, in spite the wife is delivering false statements about the father, and daughter relationship just find to an excuse not allow father to meet his daughter, what are the obligations of it?
Right. So I think the question is trying to ask, you know, if one person is lying about the husband in order to prevent the young daughter from seeing the father, and it's kind of being used as a tool to prevent the husband or the father, my apologies, to see the daughter. This is typically known as, sometimes it's known as parental alienation, and it can be complicated because, again, it's not about the rights of the parents, it's about the rights of the child, right? It's always about what's in the best interest of the child. So what that means is that, let's say that the daughter hasn't seen the father for, I mean, maybe for the whole 18 months, right? If the father hasn't been in contact with the daughter for 18 months, it may no longer be in the best interests of the child to introduce them to a father figure at that age. That's an argument that can be made. Sometimes, for example, one spouse is going to take the kids and take them away for 5 years or so. Right, that spouse did something wrong, but the way to fix it isn't to now punish that person by trying to bring back the daughters. What the courts will look at is always what's in the best interest of the child. And so sometimes it's not in the best interest to reunite a family at that point. And if it's a very short period of time, again, that's going to be very different. If it's a very young daughter, the argument can be made that, you know, it's in the best interest for the mother. It doesn't necessarily for the mother to keep the daughter. Again, it does sound like perhaps trying to prove that these allegations are false, prove that you're not going to be a harmful or a threat towards the child in any way, and that you're going to add and contribute to their value of life. Those are things that should probably be worked on in order to try and fix that situation. That's all I have for that.
Thank you, Lina. These are all questions for now. Okay.
So we'll go through some of these examples, and they relate to the divorce procedures, right? So we said Umar and Layla get married in Canada by an imam who is registered to perform marriage ceremonies in Ontario. Layla and Umar have a child together. Layla later learns that Umar is still legally married to somebody else. So is her marriage legal? And then can she claim spousal support property division? So maybe I'll give you a minute to think about whether or not her marriage is legal. She entered into a marriage not knowing that Omar already had another spouse. And in her eyes, she believed she was in a legally registered civil marriage. Oops. So like we said, that her marriage is not legally recognized, right? Because she's not legally married in Canada, she doesn't have all of the rights that a spouse would in Ontario. So she doesn't have the right to share the family property automatically like a spouse would upon separation. However, depending on her circumstances, she can still try and make a claim for spousal support, and she may be able to also get a share of the value of Omar's property that she helped take care of and improve. So it's not necessarily that she has no rights, but at the same time, because she isn't legally married in Canada, she doesn't have the rights of a spouse. Of course, like we said before, she does have the right to make claims for custody and support for her child. So but with respect to spousal support and property division, there's no statutory rights that are automatically available to her as a married spouse, at least. So just a reminder about alternative dispute resolutions. So there's a lot of different ways of trying to resolve things outside of a court, right? And you can do these types of resolutions, whether you're married or in a common law relationship. However, it's might not be the right thing for you if there is a history of family violence. But in general, I just wanted to introduce some of these concepts. So because these are some of the ways that are very frequently utilized. Not everybody goes to court to solve all of their issues. And even though you have to go to court for the divorce, you don't have to go to court for most of the other corollary reliefs, is what we call them, right? So your spouse support, your child arrangements, parenting decisions, all of those things can be contractually dealt with. So negotiation, collaborative family law, mediation, those are 3 of the common ADR methods. And then there's arbitration and mediation, arbitration, med-arb. So the thing about arbitration or med-arb is that you're essentially giving the authority for a third party to decide. And that's what they always say about the court, right? The reason you don't want to go to court is because once you're in court, you no longer have decisions, or you no longer have the authority to make those decisions about your personal life, right? As long as you're an ADR, it's an entirely voluntary process. You can stop it whenever you want. And especially outside of arbitration, with negotiation and mediation, you are always in control and you always have the power to decide how you want your family arrangements to be made. So it's definitely worth seriously considering some of these different resolution methods. And every courthouse in Ontario that deals with family law is supposed to have a FLIC, Family Law Information Center. So you'd be able to get more advice, referral, free information. And there's even subsidized mediation services that take place. So you can get up to 8 hours of mediation for a fee that's based on each person's income. And even if you don't have a current case that's before the court, you can still go and get that. And if you do have a court case, you can always even get up to 2 hours of mediation completely free. So this is to just follow up on some of the things we discussed last week about what you can agree on outside of court with respect to what we discussed today. Property division is usually dealt with in a marriage contract if you're married, in a cohabitation agreement if you're not married but you're living together. And spousal support is usually dealt with in a separation agreement, irrespective of whether you're married or you're living as common law partners. And again, these property division and spousal support are they're called corollary relief. So when you apply to get a divorce, you can apply for just a divorce. You can also apply for divorce with these other corollary reliefs. Just it's always recommended to try and make these agreements before you only proceed to court for a divorce. You want to have your separation agreement, you want to have your marriage or cohabitation agreement, of course, beforehand. But it's really important to try and get a separation agreement before you file for divorce, because that way you're ensuring that whatever you are agreeing to is done before you're putting your case in the hands of a judge. And just remember that in order for a domestic contract to be enforceable, it has to follow all those rules we talked about last week. And the most important one that relates to what we discussed today is financial disclosure. So if there is any dishonesty about how much money each person makes, what they own, the separation agreement is very unlikely to be enforced. So it's you have to make sure that everybody knows exactly how much the other person is making, and all the facts are on the table in order to be able to actually voluntarily come into an agreement. So we'll go to example 2. Now, these examples, we're going to try and learn as we go through them. Unlike previous examples where we discussed some principles before, these ones we didn't. I just thought that we'd go through them and use it as a learning tool. So Nadia and Dameen go to their imam for advice on how to deal with their family law issues when their marriage breaks down. Their imam offers advice based on Sharia. Nadia and Amin incorporate the imam's advice in an agreement that they sign. Is the agreement an arbitration award, and is it enforceable? So maybe before we try and answer this, if we just go back to the slide, like I said, arbitration is when you're enabling a third party to resolve your both sides' issues. And you typically enter into a contract before the arbitration, and that contract says, you know, I'm allowed to end this arbitration when I want. So this contract is not a domestic contract, it's an arbitration contract. It's a contract that says, this is how I want the arbitration to go. This is how we agree to arbitrate our matters, right? And so arbitration is one of those alternative ways of trying to resolve things outside of court. And just as negotiation and mediation are, however, the difference is that unlike negotiation and mediation, arbitration actually is saying, I will listen to whatever outcome you will give me. So mediation, negotiation, when you come to the table, you're trying to resolve differences, but you're not saying, I will listen to whatever you decide, oh, third party. That is not how those work usually. So, and just to introduce the term, an arbitration award is essentially the outcome of the arbitration process, right? So it would be, and typically these are supposed to be enforceable just like a court is, right? It's a contract at the end of the day. It's, again, it's not a domestic contract, but it's another type of contract saying, this is what we have come to and agreed to after the arbitration is done. So before the arbitration begins, you have a contract saying how the arbitration is going to happen. Once the arbitration is done, you then have a contract saying the results of the arbitration. And the results is what is termed an arbitration award. So Nadia and Amin get this advice, and then they decide that they're going to sign an agreement that incorporates this advice. So is it an arbitration award? No. So this question is triggering the distinction between getting advice and having that decision made for you, right? So Nadia and Amin are free to follow the Imam's advice and make whatever written agreement they want. And as long as they follow those rules of a domestic contract, right? So it can be enforceable as a separation agreement if both Nadia and Amin sign it in front of a witness who also signs. Remember from last week, we said that the law allows people to give up certain rights in their domestic contracts. If the people know what they're signing, and if they freely accept the agreement, and if they understand what they're giving up or what they're accepting, then the law will enforce those. The distinction here is that what they wrote and signed is not an arbitration award. The Imam only offered advice. He didn't make a decision, right? So that's the distinction there. So, and the other key thing to keep in mind here is, let's say that they wanted to make it, okay, so let's say now Nadia and Amin wanted their Imam to actually make a decision for them, rather than just incorporating the advice. So now that's a different scenario, right? So first, what do we have to do? You have to enter into a contract that is going to decide how the arbitration is going to happen, right? And then, so they have the right to ask for the Imam to make them a decision and to choose to follow that decision. The only thing is that if they want the Imam's decision to be enforceable by court, the Imam has to be an approved family law arbitrator in Ontario, and the decision must follow the laws in Canada. So this is a little different in different provinces, but essentially, since the example is saying that, you know, he's offering advice based on Sharia, obviously that's not always coinciding with the exact laws of Canada, so it's not necessarily the scenario in which it would be enforceable, even if it was an arbitration award. But over here, it would be enforceable not as an arbitration award, but merely as a separation agreement. Example 3, let me just see if there were any questions there.
Yes, we have one question.
Okay.
Can a wife claim 5 years child support upfront, suspecting that the husband will leave the country and not pay child support later?
So we'll talk about child support again in the next week's session. However, I don't know. I don't know that that is something that frequently happens. Like I said, there are different agencies. The Family Responsibility Office is one of them that makes sure that you know, the husband in this case does pay the child support. In general, they will be enforced. I don't know about that right now, but I can look into it for next week. Okay. So Alma and Basim agree in writing to submit their family law issues to their imam for resolution. He has training as an arbitrator from an accredited Ontario community college. He does not ask Alma and Basim to talk to lawyers to get independent legal advice. The imam determines all issues of support, property division, and custody of Alma and Basim's children in accordance with Sharia principles. Is this an arbitration award, and is it enforceable? So we'll give you a second to think about that. So no, the award isn't enforceable for two reasons. Even though it appears that the imam is an approved arbitrator in Ontario because he has the right training, that doesn't automatically make the award enforceable because number one, Alma and Basim did not get independent legal advice. Remember from last week, and we touched on it this week, that you have to have each person's that's entering into this contract to have ILA, independent legal advice, which is where they have a lawyer review all the contract and provide them advice for each side. So the wife gets her own lawyer, the husband gets his own lawyer in order to make these enforceable. And then the second reason it's not enforceable is because the imam can only rely on Sharia principles if the decision also follows the laws in Canada. And we don't really know that from this example. So I think I've answered most of the questions during the presentation, but I also wanted to just provide these links and sources. All of the examples are basically adapted from the Canadian Council of Muslim Women. They have fantastic legal resources that you can skim through on your own. And the Steps to Justice website also has very helpful information, which is another resource that I used to prepare some of the slides today. And that's it.
We have a couple of more questions. If a spouse is delivering false statements to the authorities to get out of marriage, will the divorce commence on the basis of the false statements about husbands?
Mm-hmm. So, you know, it's a very common argument that people are lying in court, right? So proving whether or not somebody is lying is something that has to be done and take place in court. It's not, you know, I don't think a court would want to, you know, what was the exact question? Will the divorce commence on? So I don't think a court would want to commence a divorce based on false statements, right? But you would have to obviously prove that those are false statements. And that's something that you would have to try and argue in court.
Thank you. And one of the participants wants to get presentation notes by email. So I think
Sure.
Yeah.
So I will definitely share the presentation slides as I did last week.
Okay. Any other questions? There is all question in the chat right now. If a spouse doesn't pay child support, can the spouse be sued for back payments?
Yeah, so again, there you would go to the Family Responsibilities Office, and they do have a means of calculating how much of the back payments are going to be provided. But yeah, if the spouse doesn't pay child support, it's not that they're being sued necessarily, but they would be obliged to perhaps increase the amount of child support payments that are coming up. Part of it would be calculating how much money they had owed in the past. So that is something that they can try and compensate, but it's not necessarily that a spouse would be sued for that. Awesome. So it looks like we're just wrapping up. I'm happy to stick around for a couple more minutes. Everybody's very welcome. It is my pleasure to spend this time with you.
Thank you so much. But I think there is a question. Okay.
Yeah. If there was a house owned before marriage and didn't live in there after several years, but lived in there for a few years, separated and moved out of the house, would there be a division of the property?
Right. So the question here would be whether or not the house is considered a marital home. And essentially, if it wasn't used as the primary residence, then no. When you're saying that it was not lived in for several years, that means that perhaps that they had another place where they were residing in. It is possible to have more than one marital home. I'm not 100% sure about who's living where, but wherever the two are living and establishing a family out of and living their lives together as a married couple in, that is what is going to be considered the marital house. So it's not any and every house that you own, but at the same time, it's not only the one place that you do own.
Thank you so much, Lina.
You're welcome.
Another questions just came. Upon false statements, may suppose has retained family lawyer for the separation, but nothing has been legally decided yet, but based on false statement, nothing can be approved. But divisions of assets are happening. I don't understand how this can be happen.
I know how frustrating it can be to be in these scenarios. Of course, it's a very frustrating process, right, for everybody. When you're in breakup relationship, a lot of statements can be made by either side and they're not always verified, they're not always accurate, and so it can get very frustrating. I think my advice would be to seek the help, the legal professional help of a lawyer, to see how you can ensure that the accurate information and evidence is before the court, to make sure that those are the facts that are leading the decision that's being made by the judge. That's all I can say. It happens where the person may not fight back about these kinds of allegations that are made, and then these false statements are what lead the decision. So I think it's important that you do get that legal support.
Yeah, I'm sorry, this is Asim here. So yeah, I'm the one who's asking all these questions. So yeah, based on that, legals are like making their money out of the pockets because they are enjoying the situation. They're making up the money from both sides. So they're not making us understand like you guys don't have to fight because whatever the other party is saying is false and something like that. So they are like my partner is providing all the false statements every time. Rather, they cannot be. There are no evidence or evident reality to prove them. So this is a hard time for me. So I'm suffering a lot at this point. So I don't understand like where everything is based on the false side. How can she can ask for like liquidation of the assets, selling the house, and dividing the property and assets? I don't understand how this can happen if nothing has been legally or on paper has been decided yet.
When you say nothing has been legally decided yet, what do you mean by that?
Because no agreements, no court order has been released, like, yeah, you are legally separated or something like that. All the relations are happening.
Yeah, I think, like I said, I would definitely recommend you get the help of a lawyer, just to make sure you fully understand all of the responsibilities that and rights that you would have. Just to make sure that you know what is available to you based on your unique facts. But it does sound like you're in a very tough spot, and I appreciate that. That's typically what happens in litigation when it comes to family court proceedings. So,
And when my lawyer said, okay, let's take her out of the court, then at that point my wife was like, okay, I don't want to go through that route because she might know that will challenge her to prove all the facts which she is delivering to the authorities, because those are the false statements. She took a step back and she was like, she reluctant to it now. I don't want to go to that route. So I don't understand how it is. Why is that? Means why she's doing it first of all, and she knows the outcome first of all, and then she's asking for the separation and asking for the liquidation of all the assets.
Mm-hmm. Yeah, I'm really sorry to hear.
That's very frustrating for me. Thank you, sister. Thank you so
You're
much.
very welcome. I'm sorry I couldn't be of more help.
We have more questions on the chat. Do we have time to answer these questions, or would you like me to send you by email?
We still have 10 minutes.
Okay.
Yeah.
Yeah.
And during the separation, if kids were with one spouse and didn't collect child support, will the spouse have to pay the amount owing from separation till what the court decides?
That is a possibility. It is a possibility, but that's something that I am unsure of right now, to be completely honest. And I think it depends on each person's situation. But when you're saying during separation, I'm assuming that means prior to divorce, but not after divorce. I'm not 100% sure what that question, the exact time frame of that question, but it is possible that the spouse will be obliged to pay the amount paying. What, like, if the court says that you were supposed to have paid it from September 1st and now it's October 30th, then yeah, the court order would stipulate that even though we're telling you October the 30th, you would have to pay that. If that's what the court decides, is that they were eligible for child support earlier than the decision at which point they granted the judgment. It's possible that that there would be an amount owing.
Thank you. Next question is, if the husband has a house before marriage, but the couple live with the parents, will the wife have any right to the husband's house when they divorce?
So I'm assuming what the question is saying is that the couple live with the parents in a different house. So the husband has house A, but the couple live in house B with the parents. And so no, if that's the case, then the couple's marital home would not be house A, right? Just because you own a house doesn't mean that upon divorce you're going to now share the value of that house if you don't use it as your marital home. And so if they don't live in it, then it doesn't sound like it.
If the spouse doesn't want to give divorce or give child support and keeps saying go to the courts and the affairs be proven in court, how is that going to affect everything? Child custody, support, etc.
So it sounds like there's an allegation of adultery. Again, that is not something that will influence the child custody and support. The only way that adultery comes into the picture here is if you are asking for divorce on the basis of marital breakdown due to the grounds of adultery, right? So that's the only way in which that limited circumstance where that allegation takes place. So if that is the case, that where the divorce is initiated not based on living separate and apart for a year, but based on the fact that adultery has taken place, then yeah, that is something that is true, that it's going to be very hard to prove in court. However, that's not going to affect child custody and support and the other corollary reliefs. Those are unrelated a little.
Do we have any other questions, Aysegul?
I cannot see any more questions right now.
I think I see one. I'm not sure if it's there for everybody, but it says, can the one who takes care of the child say that I don't want the spouse support or any money regarding child support as she's already taken of the kids without his financial help? So you can privately agree or contractually agree to give up your spousal support rights. So yes, it is possible that somebody says, I do not want spousal support. So again, you would have to put that in a domestic contract, in the right separation agreement, and it would have to make sure that it's freely done with the voluntary consent and complete financial disclosure. And as long as all of those requirements are met, it should be a legally enforceable contract where she can give up those rights.
Okay. I think so far those are all the questions that we have. Thank you so much, Lina, for the very informative session. Please, everyone, remember to register for our next session. It's going to be about immigration and divorce. And the following one, it's going to be about custody. So please make sure to register individually for each session. We're going to be sending the slides for this session in a couple of days. And thank you so much for all for joining us this evening, and thank you, Lina, for your information. Thanks.
Thanks, everybody. Thanks, everyone. Take care.
Thank you. Have a good evening.
You too. Allah Hafiz.